Hi TikTok, I'm attorney David Nguyen, and if you're new to the channel, I'm an immigration attorney and it's my job to make sure that my clients can either obtain or maintain legal immigration status here in the United States. In today's video, I just want to give you a warning that you should be very careful where you're getting your immigration advice. A very good example is a post that I saw recently on avo.com. So Avo is a website where individuals can find attorneys and they can also post their questions, and some attorneys may take the time out to actually answer their question. So let me give you an example of a post that I saw today. In this post, an individual indicated that he filed an I-751 joint petition with his spouse, but they later got a divorce. Now he's wondering if he should notify the government about the divorce and that they're no longer together, because he's very interested in applying for citizenship. Now, in the first attorney response, this first attorney indicated that he should notify the government and that he should file a waiver petition. Now, although this information is correct, there's a lot of issues with it. The first major issue is that he doesn't indicate how this should be done. So if you're a person reading this, you may just think that, oh, I can just notify the government by sending them an email or sending them a letter, and then that would be fine. However, that's not how you file a waiver petition. The next big issue with this post is that the attorney did not give this individual a heads up that when you file a waiver petition, the burden of proof or the amount of proof that you have to provide is a lot lower because you're still married to the person that gave you the green card. However, if you're seeking a waiver petition, meaning that you're no longer together, the burden of proof is very high now. So if you don't have an immigration attorney looking over your shoulder, giving you advice on the things that you need to provide to show that your marriage was entered into in good faith, most likely your case is going to get denied. And recently, on March 28th of this year, the government is stating that if you file this particular petition, the I-751 petition, if it is denied, there is a chance that the government will automatically place you in deportation proceedings. Now, this is a very big deal because imagine if that foreign national filed the case himself or filed the waiver petition, he did it incorrectly, and he travels abroad and tries to return to the U.S., the government may tell him that, hey, unfortunately, your I-751 petition is denied, you are placed in deportation proceedings, and because you left the U.S., you're no longer eligible to come back in. Very, very big deal. Now, in a response by a different immigration attorney, this immigration attorney informed this individual that in order for naturalization to occur, he must first get a decision on the I-751 petition. Now, this is actually incorrect. Nowadays, if you have a pending I-751 petition and you file for naturalization, the rules indicate that the immigration officer can make a decision on both at the same time at the naturalization exam. So as you can see, not every immigration attorney is the same. Some immigration attorneys have more experience than others, and some immigration attorneys just are better apt at handling difficult cases such as this. You might want to consider meeting with an immigration attorney face-to-face and discussing your case. You don't want to rely on an immigration attorney that is not invested in your case. Right now is not the best time to file cases nonchalantly or without an experienced immigration attorney, because what's the worst that can happen? One, your case gets denied and you lose work authorization, or two, you leave the U.S. and your case gets denied, and then now you're out of a green card and you can't even come back to the United States.